Well, welcome back to this particular conversation. Now, Wakili Kigwetha, let me come to you. I mean, if you can just briefly highlight the process from when someone dies to the last stage. I was going through the law, and there's something called, I don't know, a confirmation of grant, and I tried to understand, and I now have an understanding of it. But maybe you can also, just for a lay person out there, what does that mean?
Okay. Confirmation comes towards the end. So when somebody passes on, you get something called a burial permit. And when you get that burial permit, you use the burial permit to apply for the death certificate. So it's important that you have the death certificate. Now, if there is no will, you need a chief's letter. So you have to go to the local chief, and the chief writes you a letter saying, this person who died lived in my location, in my vicinity, and they lived in my jurisdiction. That's what the letter usually says. They lived in my jurisdiction, and they were survived by so-and-so, and so-and-so, and so-and-so. So the chief's letter will write the spouse or the spouses. It will indicate who is the spouse or the spouses of the deceased person, who are the children of the deceased person. Sometimes if the deceased person had no children, for example, or had no spouse, they'll write the mother of the deceased person is so-and-so, or the father, and the father of the deceased person is so-and-so. So what the chief's letter does is that it writes who are the closest family members of the person who has passed on. So once you have the chief's letter and you have the death certificate, the chief will also likely ask you for the death certificate. And then you put together the documents confirming the property that the deceased person owned, and you present a petition to the court. You do something called a petition to the court. And so in the family, you need to agree who it is who will become the administrator of the estate, or the personal representative of the deceased person. And the law gives priority. It says, for example, the spouse has first priority. So if it is not the spouse and you decide it is somebody else who will become the administrator of the estate, then you have to, there has to be consent of all the family members saying, we agree that so-and-so will be the administrator. All right? Okay. So people agree on who will be the administrator, and you present a petition to court where you say who will be the administrator, and you show that the other people in the family have consented. Once you put that in, that matter is, if all the documentation is in order, including the copies of the property documents, that matter is sent by the court to the Kenya Gazette. Okay? So the Kenya Gazette announces now to the whole world, to all of Kenya, that we have been asked to make so-and-so the administrator of the estate of XYZ, who is deceased. All right? So when that matter is gazetted, if anybody has any objection, if you feel so-and-so should not be the administrator, or you feel you are left out, or you feel somebody else should be the administrator, then when it is gazetted, you have an opportunity to object, to indicate to the court that you're unhappy that so-and-so is trying to be the administrator of the estate of your dad, your uncle, or your mother, all right? So you can object, or you can cross-petition. You can say, I also have a right to become an administrator, and you cross-petition to the court, all right? And the court will listen to that objection, or the court will listen to the cross-petition, and the court will determine who it is who will become the administrator of the estate of the deceased person. And then and what the court does is that it issues something called a grant of letters of administration, all right? Which means the person who is on the grant is the person who now is the personal representative, or is the administrator of the estate. Now, if the deceased person left a child, somebody who is under 18, okay, was survived by a child who is under 18, there has to be two administrators. So you need to choose two administrators. But eventually the court now gives the grant of letters of administration, And then once that happens, you have 6 months in which you are supposed to discuss and agree on who is going to get what. And then you now make an application called a summons for confirmation of grant after 6 months, where you come and tell the court, this is how we want the property to be distributed. All right? And so when that summons is made, you can all agree, and you have agreed, you give the court the mode of distribution. But if you're not in agreement, you're allowed to put in something called a protest, where you say, no, I do not want it to be distributed in that way. And then the court will listen to the protest, the court will listen to the parties, and then make a decision. And at that point, the grant is confirmed. So you get something called a certificate of confirmation of grant, which is where the court says, this is how the property will be distributed. Then you now then take that certificate of confirmation of grant, and you fill in certain forms which are found in the Land Registration Act, which are transmission forms. Those, together with the certificate of confirmation of grant, is what you take to the registrar of lands. It's what you take to the registrar of motor vehicles and say, this is how the court has said the property should move, and therefore, here it is. Here is the certificate of confirmation of grant from the court, and we have applied for you to now transfer the property so that it is no longer in the name of the deceased person, and it comes into the name of the people that the court has determined will get that property, in a nutshell. And so that is for intestate. Where there is a will, the process is almost the same, but it's fairly a little bit different. Where there is a will, you don't need a chief's letter. Why? Because as George said, the will says who are my beneficiaries, okay? So you may not need the chief's letter, but if you come and claim that you are a child of the deceased, then, you know, the court will listen to the evidence. But the reason you don't need a chief's letter, although I've seen some high court stations ask for a chief's letter anyway, and I think it's because we really believe in intestacy. We think of things in terms of intestacy, and in that case, then, but when you have an intestate, you may not need a chief's letter because the will is supposed to state who it is, who are your beneficiaries, and you don't need to be told by the chief. It is found in the will.
Well put, Okeli. Mr. Kithi, if I may come to you, we've talked about children out of wedlock. If they get the inheritance, what about their mothers? Are they entitled to anything?
Yes. In terms of inheritance, there is a hierarchy and also a confinement of who will be a beneficiary unless the beneficiary that is regarded as first-time beneficiary with highest proximity to the deceased in terms of dependence and relationship, either blood or otherwise, is not available, because there are people who don't have brothers, who don't have parents. There are those situations where the next, how do we call it? The next in that relationship of order is not available. And therefore, and as such can be done until there's no relative whatsoever. All right? Put it this way. A case probably that I need to highlight was somebody comes to live in Kenya, a German comes to live in Kenya and owns property, a car and a title deed, dies, but is not married to any Kenyan, and the relatives may not be known around even if investigated. Now, how you apply that situation is very different because there's no brother or sister. Parents are also included in the bracket of inheritance, so are children. Minor children are treated differently because they can't own property at that time, and then guardians will be appointed for instance, if they go to school or they have to be oriented differently. I want to point out one issue that is important, which my colleague has stated, and I see it many times when we're doing the succession cases in court. An administrator is not an owner of the estate or the property. Let me put it this way. So if you're an administrator of land, you don't own that land. You probably, your proprietorship to the land is to the extent of representation of the deceased because he owned the land. You are waiting for partition or distribution of the property. So do not buy land from an administrator. Wait until the property is divided, and then you enter into an agreement to buy that property. I've seen it many times that by mischief or by probably ignorance of administrators may want to buy land, or you are convinced to buy land from an administrator on account of, the fact that, well, you're looking for land, you have the money, and the land is available, and you want to buy it. Number two, if you buy land from a dead person, which you can't, but a dead person through the children, so the children say, we have problems. Mm-hmm. Our father died. We have the title deed. Because we are the legitimate children anyway, we want to sell the land to you. That's illegal. So that is an invalidated land transaction, and the sale agreement can't stand. But when they go through a succession process, and this is probably a saving situation, when you go to court, when they go to court for the succession process, mm-hmm. there is the credit side of the estate and the debit side of the estate, meaning the estate must satisfy also liabilities as well when the deceased passed on. So a bank will take its money from the estate if, for instance, a loan had been taken, and other people that are in debt. So if a person had probably bought land, expended money, and there's evidence for that, that becomes one of the people that ought to be paid for that expense. Or at the time of execution of partitioning of the property, those that took the money instead took the money to the property. So the land is 5 acres, those are 5 children, but one of the children took money in relation to the portion of one of those acres. Then the person who ought to get that title because of the purchase can again petition the court, and the land can be ordered to be transferred to that person in lieu of the one who was supposed to inherit to take that portion. All right? So it is very important for the listeners and those that are watching us to know that deceased property can only be through the administration of the court. That's why we call it an administration process, other than acquiring it directly from those that will be heirs who have not satisfied the court process yet, because that invalidates the sale transaction and can only be validated at the partition if you're lucky enough. Otherwise, the illegality is constant until the estate has been distributed. I hope I'm clear on that. Okay. Because these are cases that we see many times in practice.
Okay. Yeah, let me add, because it's very, very common, and people love to buy land because from the beneficiaries of a deceased person.
Because they're desperate.
And they're looking for money. So you pay the deposit, is the one that is being used to go to court for the succession. But what if you buy from 3 children and 3 other children emerge? And it turns out the person had 6 children, and you are buying their 1 acre. How are you going to deal with the other 3 who are not involved in that purchase? So it's something that people really need to be careful about, because it's very, very common in the country that people are buying property that is subject to succession, and you don't know how the dispute will end up when the court comes to make a decision on who is the true owner of the property.
Okay, but even as you talk to us about that, there's another concern, and there are vulnerable groups. You talk about widows, you talk about daughters in some cases, but also there's the aspect of, for example, a PWD child. Mm-hmm. Does the law protect them? Because sometimes they get disinherited and then nothing happens. Does the law protect a PWD child?
Yes, the law will protect a child who, for example, is living with a disability. But you have to be, and that's a reason you should write a will, because the way our lives are and the people you leave behind, you have to trust that they will take care of your child who has a disability. So one of the ways you could take care of a child who has a disability, to make sure that, that they're taken care of when you're gone, is, putting putting it in a will and explaining that I'm giving a bigger portion to this child because they may not be able to take care of themselves in future, while my other children are able to take care of themselves.
Okay.
You can also do a trust. If you do a family trust where you put specific property in trust for that child, that matter, the issue of the property that is in trust does not have to go through the succession process. So while you're still alive, you can do something called a living trust where you register and incorporate a trust and put property in that trust for your child who is living with a disability, so that then it doesn't have to go to succession. Maybe your other children can go to succession and fight over everything else, but this one that is in a trust is specifically taken care of. It is specifically preserved, reserved, and continues to generate an income for your child with a disability. So it is important that you could try and take control, because you don't know what's going to happen after you're gone, and try and take control and take care of this child. Because when the law talks about dividing between children, for example, the children may be treated with equality. Of course, when you go to court and it turns out there's a vulnerable person, the court will take into account the vulnerability of that person. But because of the uncertainty of the future, you don't know what deaths are going to accrue at that point and who is going to come for property and what's going to happen. For children with disability especially, it will be a good idea for you to set aside, register a family trust, and now the law has made it easier for you to register a family trust so that there is property reserved specifically for that child and nobody else is allowed to touch it. Even if you get into a debt or a case, that nobody can come for that property because it is reserved in trust specifically for that child. So there are many ways you could estate plan, and of course the law will look at the vulnerable individual in your family, but to avoid all those disputes and fights, and to avoid certain uncertainties, there are certain things that you can put in place that take care specifically of vulnerable members of your family.
Okay.
Let me just put it this way. Very interesting is that value in a property that is put into the will is the value of the person distributing his properties while alive. For instance, if you put into the will. Let me put an example. If you own a guitar and through your lifetime you've cherished it, you cannot give it to anyone else, but I'll give it to my firstborn son. That guitar is so important than the title, the property of the title, the title of land or a car. So it will be enough for me to give you the guitar because either it gave me good luck or it is symbolic to your birth, or for whatever reason, I attach it to you. So you will see, for instance, that I give this one, this property, this one, this. But when I give you the guitar, I cherish the value of the guitar that is more emotional, attached, or for whatever reason. I could have got it from my father, and I was told and instructed to give it to the firstborn. Or maybe I named my father, my firstborn, in the name of my father, so I'm bequeathing you the value of what I have. Now, that is important because the presumption and fair and equity here will be if I give you 1 acre and your 5 sons, the other 1 acre, the other 1 acre, the other 1 acre, the other 1 acre. Okay? So the law does not read into the will to mean that if I must give you what I give you at the others in terms of value. So what? I don't look for valuer of the properties and say, this is the type of distribution equally that I'm going to do. It depends on what I see as valuable to be able to bequeath. The only thing is, and it is inheritance does not mean that those that get little in value, monetary or financially, and those that get more, that is disinheritance. Disinheritance means I have not given you anything. For instance, I don't mention you at all in the will, yet you are my son. The other issue that we need to confront, therefore, and the opposite of that is when it is intested.
Briefly.
We look at the value when it is intested. Okay? The value will, the first line of distribution, then the special circumstances like disability. For instance, a child who is disabled cannot fend for herself or himself, such that then at the time of consideration on what that child should get, through logic and circumstances that are special to the environment that will be prevailing by, as will be before the judge, then you will realize that maybe there's a bias of more of the allocation of the value of property financially than the rest. So when you don't do a will, you will allow the public, meaning the court, to be able to administer the distribution as will be fair to those that you leave behind. All of them that come.
Okay.
The beauty about a will is that you are able yourself to say, this car is what took you to school when you were in high school and university. You should own it. Cherish it because it will give you the following value. This car has brought me good luck. I want you to take it. It will also bring you good luck. There are those special circumstances that you determine when you are doing the will. And let me talk to men now, if you allow me.
Briefly.
I allow you.
To avoid these disputes, one is, I don't know when you know you will die, but if you know, you can transfer all your properties to the people that you want them to own them. Then you have nothing to distribute, so there will be no dispute. The other one is to make a will, so that then the will pronounces itself on how you want the property to be shared. Otherwise, you leave it to the public and the court representation and how they'll do it. The third one is to create then the estate, the family estate, as she has aptly put it. That then the trust. So that the trust will, basically it's a process of succession, but it's personal to the properties that then will be in the family line or wherever people you want to be beneficiaries, including, for instance, if you're supporting orphans or other people. And you can say part of the estate or part of the trust, what the process should be like. You want them to go to church, you want it to go to charity. So you're able to manage your properties according to your will. So also the trust is another form of giving out your will on what needs to be done to your estate.
Fair enough. Wakili Kigwatha, there's another concern, and I talked about vulnerable groups. For example, there's a widow somewhere. A man got married, but unfortunately, he died without a will. He left a widow and children. But they get disinherited. Some get evicted from even their homes. What happens in that case? Are there maybe legal or constitutional remedies that can help them in that particular moment in time?
Actually, the Constitution talks about protecting the beneficiaries of deceased person in occupation of land. Because in some sections of our society, as soon as the person dies, the widow is told that, the person who brought you here is no longer here. So you're supposed to leave, and they really try to push you out. And you'll be surprised, actually, at how many times this happens. And it's a real concern in law. Now, where there is no will, the law is very clear that where the property of the deceased, especially where the deceased has one wife, or one spouse, I can say, the spouse is supposed to hold that property for life. They have something called a life interest. Where you live, your matrimonial home, you have a life interest in that property, which you are supposed to hold, occupy, and enjoy in your lifetime. And then when you pass on, that's when it passes on to the children. So it is illegal. It is unconstitutional. It goes against our Law of Succession Act. It goes even against our national values and principles that are set out in the Constitution, and the values and principles for holding land under the section of under the chapter of the Constitution that talks about land. Because land is supposed to be held equitably, with equality, with protection of vulnerable groups. So all those, when widows and their children are evicted and thrown out of their home, that was their home when the person, when their father was alive, all those go against our laws. And so there are processes that are in place. You can go to court, and the court will reinstate you into your home. Then also, we actually have an act called the Protection from Domestic Violence Act, where you can go and ask the court to stop other family members from violently, treating you with violence that forces you out of that home. So it goes against many of our laws, and therefore the law does protect you from being removed from that property which was your home. And it's spoken about actually right in the Constitution, which is the supreme law of the land, is saying there should be protection of vulnerable people, especially from eviction, as beneficiaries of the deceased person when the deceased person has passed on.
Okay, Kithi, we are running out of time, but for those who are in polygamous marriages, there's the wife that maybe he lives with. There are the known wives, but the first wife says they cannot, get equal shares in terms of, the inheritance that, has been left behind for them. Can the other wives contest that? And what happens in that particular scenario?
Interesting question. Of course, we face it every time. Legal polygamous marriages, if the man is deceased, all the wives that have been left behind and the children will have equal rights to inherit. All of them have capacity to inherit in the property at intestate. If it is tested, or if there's a will that has been left behind, then the purpose of the will, then they should not be disinherited within the context of the allocation of the estate to all of. So all of them will be treated equally by the law. Now, the question, that sounds simple. It's different if it's polygamous in the context of is married in church with a marriage certificate, but gets married to another wife, they have children, and they live well. So you cannot procure a second marriage when you're married in church with a certificate. So you can't procure a second marriage and call it a valid marriage. Now, the question will be, if that person, that second wife, in quotes, can then inherit. And whether the children out of that marriage can also inherit. It's worse if you paid dowry customarily in the second marriage, all right? So will that then be in the bracket of inheritance or not? I think circumstances keep on differing because we can have the same case throughout. But for that theoretical aspect, it will be this, that for purposes of the proof of dependence, you can inherit. That is one. Number two, there's always the principle at the test of how the community took them to be. Okay. For instance, if they lived in the same family, yes, they've lived in the same household throughout, the first and the second wife. Although the first wife is by church marriage and the other one is by customary, the context becomes different. It depends on how the circumstances were at the time they lived. The children, there is no contest on the children. But I want to repeat this. And this is important because I know we face it every time. A woman, a wife, is a stranger to the family she is married to. But once she joins, she assumes rights that can't be wished away. When the husband dies, in that family, she is not to be treated as a stranger. In fact, she is the heir apparent with the first right to the properties and the house. So the brothers, the sisters should not evict the wife of a deceased brother on account of the fact that she came from a different family, probably of a different ethnic group, or you didn't get along with her when the husband was there, or she didn't welcome you to her house. It doesn't matter. She was the wife, and she has right to that property, and she's protected in law to that extent.
Okay, as you give me your final submissions, Wakili Le and Mr. Kithi, there are two things. One, sometimes these succession cases takes years. And Article 50, if I'm not wrong, talks about fair hearing without delay. Does this violate this particular article? And what can be done about it? And secondly, there are instances where there are families that are underprivileged and they've been disinherited and they have nowhere to run to. They don't have the money to go to court. So Article 48 talks about the state shall ensure access to justice for all. How can they get help? Briefly.
Your first question was about...
these cases taking long.
The cases taking long.
Yes.
I think one of the reasons that sometimes succession cases take long, and that's a problem with our Law of Succession Act. One of the problems with our Law of Succession Act is that there is no time limit for bringing the case, and there is no closing of the case, so that you think you have finalized, and then 10 years later, somebody can come and reopen and say that it was not distributed fairly, or the grant should be revoked, or it has not yet been distributed the way the court says. So that lack of a time limit in our Law of Succession Act causes cases to take long because people can come and keep reopening. But I have to say that the courts are really encouraging families to talk, sending them to mediation, trying to see if people can do alternative dispute and resolution and come to the court with an agreement. There's really a push in courts, especially for succession matters, because these are family members. If you fight with your brother, even if you win, you have lost your brother. This person will always be your brother. So the courts are really encouraging alternative dispute resolution and making sure that people can continue to finish their cases quickly. For people who are very vulnerable, there are many organizations such as FIDA, the Center for Rights Education and Awareness, CRU, and the National Legal Aid Service that can help you go to court and do a pro bono case for you and help you do this. And then also, depending on the value of the estate, we have the public trustee. And you can go to the public trustee, and the public trustee will help you to do the succession case and to be able to administer the estate. And the public trustee is under the AG's office. Yes. But I want to point out another misnomer, another issue in our law.
Briefly,
and George sort of alluded to it, that we have a section of our Law of Succession Act that talks about a wife for purposes of succession, who may not be a wife when the person is alive. And maybe, George, you could have spoken a little bit this more and speak to the men. Because when you're married in church, you cannot marry somebody else. You're not allowed. When you're married, civil marriage, you cannot allowed to marry somebody else. When you're married under a Hindu marriage, you're not allowed to marry somebody else. There's no polygamy in those three types of marriages, as long as the man is alive. But the Law of Succession Act comes and says, well, it doesn't matter. Once the person is dead, these other wives can come. And that's one other reason why so many cases in court and why so many cases come. And some people are told you're not a wife, and some people are told that they are a wife. So the issue of wives and polygamy, I think Ian might be a case for another whole 1 hour of a discussion. But that's an issue with our law. And maybe that's something we should consider in future as our law evolves for review.
Thank you. Wakili, briefly, kindly.
Yeah, thank you. It is important for viewers and listeners to understand that one day you're going to die. I mean, I wish you luck, but you're going to die somehow, somewhat. And if you die, there'll be problems if you do not plan your estate well. What you leave behind, you'll not be able to control once you die. So it is important that you take time and write down what or your wish, how you want the property to be shared, especially by your children, immediate family, and your wife. Remember that it is not true that it is the man who dies first. Also, women, please understand you can die first. You need the property to be taken care of, especially for your children and for your husband. You know, in families, we have problems. Once you get married, it is nice, but later you look at you, because you have a problem with your wife, you say, I don't know how to get anything, all right? And you hide properties out there in people's names. That's very dangerous. I've had that experience in cases out there. Once the proprietorship or the name is in someone else, including your friends, because you are hiding the property out there, it will not come into the fold for inheritance. So then it is important that you put your documents properly for purposes of protecting the estate, so that if you die today, tomorrow, because somebody's going to die today, tomorrow, 5 years, 50 years from now, that then the estate is properly managed according to your will. And that is, there's nothing like if you do the estate, you're calling for death to come close, because that probably is a belief. No. It is far off to the extent that God warrants it. And it is as near as it is because God has said so, but not yourself, because we have not control of that eventuality.
Okay, pretty much. Many thanks, Wakili George Kithi, Lea Kigotha. Always a pleasure hosting you around. Land is a very emotive, subject or issue here in the country, but there you go. Of course, we'll find time to have a more, in-depth conversation, like how Wakili Kigotha says. We need to have another conversation in regards to those in polygamous marriages. We'll find time for that. But many thanks for, of course, joining us in this particular conversation. Until next time, do have yourself a wonderful night, and like always, God bless.